noches. Welcome everyone to our final session of LibertyCon 2019. What an incredible couple of days we had together. LibertyCon represents something different in today's political climate. At a time where it seems like everyone is hyper-partisan, an event like this shows us that humility and honest inquiry can win out. So for that, I would like for all of you to make a random applause and making this event possible. Thank you. Tonight we kick off with a fantastic panel on criminal justice reform. Many have asked us, why does criminal justice reform matter? Well, it matters because our governments are punishing people for victimless crimes. It matters also for simply the reason that being arrested for possessing things that other people don't like. LibertyCon represents a voice for change, and this panel will do exactly that. Please help me welcome Professor Randy Barnett with Georgetown University, Jerry Budding, attorney featured on Making a Murder, and Sean Hopwood with Georgetown University Law Center.
Thank you. Thank you.
Well, I'm Randy Barnett. I'm a law professor at Georgetown Law School, and I went to law school to become a criminal lawyer. That was the only reason I went to law school, and I got to be a criminal prosecutor with the Cook County State's Attorney's Office in Chicago, which is a state court prosecutor trying murders, rapes, and armed robberies. And my very first substantive scholarly article was on restitution to victims of crime as an alternative to punishment, how that was an alternative paradigm that our criminal justice system should have. So I was actually very pleased and honored to be asked to moderate this panel with two extremely exciting guests. The first is Jerry Budding of the state of Wisconsin. And you probably all, how many of you have seen the show Making a Murderer? As you know, Jerry was featured very prominently in season 1 of that show as the lawyer for Stephen Avery, and we have a lot of questions. I have a lot of questions to ask him about that show, in addition to his opinions about criminal justice. And my colleague Sean Hopwood of Georgetown University Law Center, my colleague law professor Sean. Sean has the distinct background of being the only law professor in the United States who served 11 years in federal penitentiary for armed bank robbery.
Well, five armed bank robberies.
Five armed bank robberies. We want to make sure we get that out there. Right. So this was not a wrongful conviction.
No.
But he had to do 11 of his 12-year sentence, and 13-year sentence, and after that, he went to law school at University of Washington Law School, passed the bar, and he's now one of my colleagues. He's in his second year teaching as a tenure-track law professor at Georgetown Law. He was also instrumental. He was also instrumental in developing and pushing for the First Step Act, which is a criminal justice reform bill that was just enacted by Congress and signed into law by President Trump, and he worked very closely with the White House in pushing for that bill. And so I want to ask him questions about that. But Jerry, let's start with you and Making of a Murderer. So you went to law school to be a criminal lawyer as well. And then you became a public defender in Wisconsin, is that right?
That's right. I was a public defender for about 9 years in Wisconsin, and then I've been in private practice ever since, and I've done almost exclusively criminal defense, a little bit of civil rights work involving prisons, but almost exclusively criminal defense.
And how many years were you a defense lawyer when the Avery case came your way?
I was already about 25 years in practice at the time that happened, and so I'd seen a lot. There weren't a whole lot of things I hadn't seen by the time I came to that case, and then I saw a few more.
So my first question of you about the case is, what was it about, well, actually, that's the second question. The first question I want to know is, so what was it like, and did you have any qualms about handling criminal defense while being shadowed by documentary filmmakers?
Oh yes, had a lot of qualms. Because I knew that, first of all, that we would have no editorial control over what happened. You know, keep in mind, though, that at the time that these were two graduate students in film at NYU in New York. And so they didn't have a lot of financial backing. They had no financial backing, really, and we weren't sure if anybody would ever see it, other than maybe a few people in some art house in Greenwich Village or something.
This was actually pre-streaming, too.
It was.
Didn't even have that market.
There was no streaming. There was Blockbuster. I mentioned this in my book. Blockbuster Video had a chance to buy Netflix for $150 million, turned it down.
Most of these folks don't know what Blockbuster Video is.
Well, Blockbuster is no more, and of course, Netflix is unsurpassed. But so we didn't really know if it would ever be seen by anybody, but we were concerned about two things. One, and this was part of the bargain that we agreed to, that they would not film any attorney-client communications between us. And so when you hear Stephen Avery's voice on the Making a Murderer, it's phone calls he's having either with his family or the filmmakers. And that it would not air, not even a trailer, until after both Stephen and Brendan's cases had been tried, which took 9 years, so it's kind of laughable that we were worried about that. But we ultimately agreed to do it, and because we thought that this would be really an interesting. Defense attorneys, up until Making a Murderer, have just ever since Perry Mason days, and I'm sure nobody here knows who that is, have always been portrayed as the bad guys, defending the guilty, not defending individuals' rights, and that's never been portrayed. It's always been that prosecutors and police are the ones who have this monopoly on truth and justice. And we know that's not the case. And so we thought that this might be a way for people to get a better inside look at what it's like to be a criminal defense attorney preparing for a serious case like this. And so we thought, it'd be a good public education opportunity, having no idea that this would have this huge audience of 40 million people or whatever it is that have seen it around the world.
So as a defense attorney in this case, this very high-profile case, but having had a lot of experience, what surprised you the most? What did you learn about our criminal justice system that even you didn't know about before you went into this trial?
A lot of it was not that surprising to me, from everything from what appeared to us to be police officers lying under oath, witnesses lying under oath. I mean, anybody who has done either side of the criminal defense or criminal justice system sees that, knows that happens. But what I think surprised me the most is something that happened the day right as I was getting onto the case, which was that incredibly inflammatory press conference that the special prosecutor did, in which he described this horrible, gruesome, rape, murder, torture, dismemberment of a body, live on all 7 media markets throughout the state of Wisconsin. And there are limits there are ethical rules that lawyers are supposed to abide by in terms of making extrajudicial statements outside the courtroom about things that aren't being dealt with in a courtroom. And I was really shocked to see him go that far. Now, at that point, we didn't have any of the discovery. We didn't know what they clearly knew at the time of the press conference, which was that the forensic crime lab report showed there was no blood in the bedroom. There was no cut hair. There was no DNA at all of Teresa Hallbach's anywhere in his residence. And so it was all the more shocking when we discovered that. And so the judge, right after that press conference, increased Mr. Avery's bail by like another $250,000, specifically because he said, we have all this direct evidence now. And so when we got those reports, we filed a motion to reduce his bail back to what it was and said, Judge, everything that you were told was wrong. Here, we attached the crime lab reports. We attached all the detail about how that was false and filed it. And normally, documents are not sealed, and the public can see them. it was not in the back of, very far in the back of my mind that the media would look at this and say, hey, wait a minute, there's another side to this. But interestingly, and this was surprising, I've done cases in smaller counties all over the state many times, but somehow or another that bail motion that we filed never got put in the court file. It was never filed for months, and so the media never saw it, and so no one ever saw the other side until the case was actually tried, and by that point, everybody thought that it was, everybody still, to that point, almost a year later, thought that that press conference was what happened and that I was defending this monster.
Had you ever defended a case that involved a police frame defense before this case?
I had, not to this extent. It was more of, we used to call them, when I was a public defender in the 80s, when there was a lot of street drugs, and that's when the war on drugs started, and we're still suffering the consequences. But we used to call them dropsy cases, because one of the exceptions to Fourth Amendment searches and seizures, reasonable searches and seizures, is if the police find something in plain view. And so they would claim that these seasoned drug dealers on the street corners would be exchanging money, and that they would come up to them, and immediately they would, in front of the police, take out their drugs and drop them on the ground right in front of them. And, oh, look what we found here, you know.
Also, guns have a tendency to slide out from under seats.
That too, furtive movements, all kinds of things like that. And so, you know, prosecutors, defense attorneys, and judges all knew the police were lying about that, because, come on, how many seasoned drug dealers think that they're going to just drop their drugs in plain view and not get arrested? Instead, they were searched and hands down in the pocket illegally without probable cause or reasonable suspicion, but would never testify to that because they wanted to make the convictions stick, the arrests stick. So, you know, to that extent, yeah, I had a number of cases like that.
But there's sort of a line in the criminal justice system that law enforcement tends to follow, sort of enhancing things for purposes of search and seizure laws, and actually just incriminating somebody with false evidence, a genuine police frame of an innocent person.
You'd hope so, but it's oftentimes, it's not that they deliberately set out to frame the person who they believe is innocent. Most of the time, and Dean says this in the Making a Murderer, that most of the time they've made up their own minds that the defendant is guilty, and they're going to do what they need to help that conviction, to augment the evidence, to make sure that person is convicted. But, you know, if we're going to allow that, why do we have jury trials? I mean, why not just let the police decide who's guilty or not? You know, that's so contrary to our traditions and our Constitution and requirements. So, you know, despite that, you're right, there are actual documented cases all over the country where police have actually planted evidence. There's actually a case where somebody, believe it or not, a fingerprint is fairly easy to plant with a piece of Scotch tape. And there are police who've gotten caught actually transferring someone's fingerprint onto the crime scene. I mean, there are few, thankfully. The vast majority of police don't do this. But there's enough of them that it's of concern. And most recently in Nebraska, I believe it was, a crime scene investigator got caught planting blood of a suspect in the victim's car, very similar to what we thought happened in Stephen Avery's case. But he got caught, and thankfully, because you don't see this very often either, although this is starting to change, they prosecuted the officer, or in that case, the crime scene investigator, crime lab guy. And not only prosecuted him, but convicted him and sent him to prison.
I was involved in a case when I was a law student in Chicago where a police sergeant inadvertently shot himself during making an arrest, and he was trying to separate two guys, and then after he did that, he was actually wearing an illegal pen gun in his pocket, and the gun went off without him realizing it. But he didn't know that, and so he said, "Which one of you two guys shot me?" And it turns out, because he thought he'd been shot by one of them, turns out he'd been shot by neither one of them. He'd shot himself, but at the time he realized that, he was in the hospital, and it was sort of too late, and he wasn't supposed to have this gun. So that particular suspect spent 11 months in the Cook County Jail before someone finally informed on the officer. We took a plea in that case before somebody informed on the officer that he had shot himself. And then that officer actually also was indicted and went to the penitentiary as well for perjury.
Good.
I have one more question to you, Jerry, before I turn to Sean, and then we'll come back to you to talk about reforms of the criminal justice system, and that is the question I told you I wanted to ask you about, and that is whether defending an innocent person poses different challenges than defending the guilty. In my experience, the overwhelming number of people who are charged with crimes are guilty, in part because of the existence of defense lawyers like yourself who serve as a deterrent to bringing wrongful prosecutions, because every prosecutor knows they're going to run into a defense attorney down the road, so they better have the case. So most people are guilty, but there are people who are not. And then the question is, do they require a different kind of defense if you're not guilty than if you're guilty, and how well the system deals with the genuinely innocent, given they tend to believe that most people are guilty. Do you think and has your experience with the Avery case led you to believe that you sort of have to adopt a different technique in defending someone who's innocent than someone who is guilty?
No, I don't. I think that there's a real risk if you do. We were talking a little bit about this. The other way to frame the question is that because many people are rightly concerned that the presumption of innocence has disappeared in our modern society, therefore, do you try and take on that burden and try and, even though you know that there is a quote-unquote presumption of innocence, if you have an innocent client, do you really try and prove they're innocent? Whereas if you have a guilty client, how do you do that? It's probably difficult to, more difficult anyway. But the problem there, I think, is that then you fall into the trap of what the prosecution wants, which is for you to take on the burden. And if you start taking on the burden, it's very, very difficult. There's a reason we have a presumption of it, not just America, but most of the Western world anyway has a presumption of innocence in their justice system. And the reason is because if someone's going to accuse you of something, it should be their responsibility. It's much more difficult for you to prove you didn't do something, to prove a negative, than it is to make somebody prove the positive. So, if I say you had a piece of pie for dinner last night, you may not be able to prove you didn't because there's no evidence left. So how would you ever prove you're innocent of an accusation? And so there are a few cases where you can do that. DNA has made that more possible to do, and but by and large, it's tough to do that. So I try and resist taking on that burden of trying to prove my client innocent. Now, I recognize that jurors don't come into it that way. They don't come into it thinking that the presumption of innocence applies. They don't apply the presumption of innocence when they're parents and one child comes in and says, he started the fight, and the other one says, no, he started it. And you know your kids, maybe one of them lies more often than the other, and you're going to presume that person is lying. But you can't, I think if judges instruct jurors properly and make it come alive to them, then we can try and recapture the presumption of innocence, at least in the courtroom. What I do, though, is to try and give them some ideas of, if it's a case where I'm saying that the accuser has fabricated the story against my client, well, people would say, well, why? Why would they do this? Or why would they frame Stephen Avery? Or why would the police do all these things? And so you have to think about possible answers to that without saying, look, I can't prove this, and I don't have to prove it, but there, from human nature and common sense, there are reasons to think why this person could lie, and why they might try and frame.
Fake, thanks. Sean, you've been sitting here patiently. You here on this panel are really talking about a different aspect of the criminal justice system, not how you get someone into prison, but what happens when they get in prison and when they get out of prison. I highly recommend to everyone here that they buy and read Sean's book, Lawman, where he discusses what happened to him that got him into the position where he became an armed bank robber. Why don't you, it's a fascinating read, Unfortunately, not available for sale in the bookstore outside here, but Jerry and my book are for sale at the bookstore outside here, which we have copies of here. We just each signed copies of a book for each other, and both of us will be happy to sign copies of books for you if you want to meet us at the bookstore after the program. Sean, in your book, you tell this riveting story about your own life. Can you just give us just a brief thumbnail sketch of how a guy like you could go from high school basketball star to the United States Navy, service in the United States Navy, to an armed bank robber caught and prosecuted for 5 armed bank robberies?
A lot of stupidity. My choices back then, when I was in my early 20s, were really bad. One right after another after another. And next thing I know, in 1999, I am in a federal prison with a 12-year, 3-month sentence, and basically thinking that life is over. Fortunately, I got, kind of magically, a job in the prison law library, and what I found was I didn't like the law books. They were big, they were thick, they were intimidating. When I did pull one off the shelves and read it, it felt like it was written in another language. And so I didn't have anything to do with the law until the Supreme Court decided a case in 2000 that I, along with every other person in federal prison, thought could lead to a sentence reduction. So all of a sudden, I had a lot of motivation to study the law. And study the law I did, and spent 2 months preparing a brief and sent it off to court, and then got a letter back about 3 weeks later saying, Mr. Hopwood, it would really behoove you to file your brief in the correct court. So that was the start of my legal career, pecking out a brief for myself on a prison typewriter and promptly filing it in the wrong court.
Yeah, but then you really went on to file some other briefs.
I never was able to get any legal relief for myself, but what I found was I enjoyed this process of solving the legal puzzle and then writing out the solution. And so I started writing legal briefs for other prisoners. And it was either the second or the third brief I prepared was for a man named John Fellers, who was filing a brief in the United States Supreme Court, which is a little different than filing in other places. Court gets about 7,000 to 8,000 petitions a year. They grant 70 to 80 of them. You've got about a 1% chance of getting your case heard. But that 1% chance is for lawyers filing briefs, not indigent federal prisoners where on the front cover of the brief where the lawyer's name was my friend John Feller's name, the defendant's name. And so the chance of getting that case heard is about 1% of 1%. So I was very astonished one morning, headed out to the recreation yard, that a friend of mine came running and screaming out of the housing unit. And this being federal prison, I thought, what did I say to him yesterday that he wants to come fight me at 6:30 in the morning? So you see people running and screaming at each other in federal prison, not a good sign, not a good sign. But what he had was a copy of the USA Today saying that the Supreme Court had granted John Feller's case, saying how unlikely that was given that he had filed without a lawyer, and it even quoted a couple of those sentences that I had pecked out on that prison typewriter. And you would have never convinced me that I would go on to become a lawyer, and certainly not a law professor at a law school like Georgetown. But I did know it was a big deal because I became very, very popular in prison. There weren't many days I couldn't walk across the courtyard where somebody didn't say, hey, Sean, you got 5 minutes? Let me tell you about my case. Which is ironic because now I get probably 50 of those letters every single day in my mailbox saying, hey, can you take a look at my case? So from that perspective, things haven't changed a whole lot.
So then Seth Waxman, who was formerly Solicitor General of the United States, he was the one that handled the case in the Supreme Court, and he involved you in the preparation of oral argument.
He did, and I think someone like Seth Waxman, Harvard undergrad, Yale Law School, clerk for federal judges, rose through the DOJ to become Solicitor General of the United States. I think most people like that would have said, hey, great job, Mr. Jailhouse Lawyer, who doesn't even have an undergraduate degree. Great job getting the case heard, but we'll take it from here. And yet, Seth and the law firm Wilmer Hale kept me involved with the whole case. I'm probably the only person ever in federal prison who was receiving drafts of a merits brief that were going to be filed by a former Solicitor General of the United States. And I found out later that Wilmer Hale had a nickname for me, that I was in-house counsel, as in the big house.
That's great.
So very briefly, because this is the question everybody asks me when I tell them your story, and that is, how the heck, I mean, you went on to be at the University of Washington Law School, and I know the dean of the law school, Kelly Testi, was instrumental in getting you admitted to that law school. And then she helped fight for you to pass the bar as well, and she's very proud of what you've done. But how the heck did you get admitted to the bar? That's the #1 question I get from everybody about you.
Well, yeah, I mean, the bar has this thing called the character and fitness test. And it turns out if you have multiple armed bank robbery felonies, they tend to think you don't have the character and fitness necessary to practice law. Although, having spent a lot of time around lawyers, I think their view of themselves is probably way too high. You know, I can't tell you how many times over the past 10 years people have written articles about me, and I've seen comments on the internet saying, you know, transition from bank robber to lawyer seems pretty seamless to me. So I was fortunate that, you know, by the time I went to apply for the bar, I had almost 20 years since I had committed my crime. I had done a tremendous amount of volunteer work and had worked for a federal judge and done some other things, and was in a state that really believes in second chances and rehabilitation, and the bar said yes. And ultimately, the Washington State Supreme Court said yes. And now I kind of work on this issue all over the place. I have, at any one time, between 10 to 30 people I'm mentoring who are on their way to law school, thinking about law school, or in law school, who have committed felony crimes at some point in their life. And last fall, or 2 falls ago, I actually represented a woman who had been denied by the bar, who had just overcome the most horrific childhood you could imagine, homelessness and verbal and physical abuse and drug addiction and sexual assault, and in and out of prison twice, and bankruptcies. And then 6 years ago, she just completely turned her life around, went to law school, won all of these awards, graduated with honors, and had 50 members of the bar, 3 state court judges, and the prosecutor all filed letters of recommendation on her behalf. And then the bar denied her 6-3 and said, all of the good things you've done for those 6 years are outweighed by the 20 years of bad things. And we took her case to the Washington Supreme Court, and for the first time in 37 years, they granted full review, and I argued the case, and it was basically a simple argument at its core. Character's not static, people change, and the law needs to recognize this. And I was on the plane ride home from the oral argument, and my wife texted and said, Tara just left a message and said you won. And I said, that's impossible. State Supreme Courts don't issue same-day decisions. But as with so many things in life, I was wrong. And 2 hours after the oral argument, the court entered a unanimous order saying that Tara Simmons had the character and fitness necessary to practice law. She took the bar exam last February, passed, and last March the bar came out with a 33-page opinion that said, hey, listen, we as a profession have discriminated against women and people on the basis of nationality and race and sexual orientation and political beliefs, and we really should quit doing this, even as to criminal history, because people can change. And this past June, I flew out to Seattle and watched as Tara Simmons was sworn in as an attorney with 2 members of the Washington Supreme Court in attendance. Fun case.
So before we move on to criminal justice reform, and we only have about a little more over 10 minutes left, I do want to point out that you were very active at University of Washington in the Federalist Society.
I was.
And I think you consider yourself a political libertarian, do you not?
That's true. That's true. And there are few groups in America that should be more for criminal justice reform than this group. You cannot believe that we are the land of liberty on the one hand and acknowledge on the other that we incarcerate people in this country at a greater rate than almost any other country on the planet. Those 2 things are fundamentally incompatible. I mean, we still have people today, this very day, serving life in prison without parole for marijuana offenses. Life in prison for a plant. We have lots of other people who are given mandatory minimum sentences and who have gone to prison and not been rehabilitated or corrected, but have been crippled. And then we send them back out into society after putting them in the worst environment possible, and then we expect a miracle to happen. And when it doesn't, we say, oh, you were evil to begin with, when these are mostly the people I saw in prison weren't evil people. They were just people that made bad decisions. And the goal of government should be to let them come out of prison better off, not worse. And if we did that, I think you would see a criminal justice system that's more fair, more equitable, and certainly one that protects liberty better than our current system does.
Very good.
So tell us about the First Step Act. I mean, it's not all that often at a Libertarian conference that there's actually good news on the legislative front. In fact, it's not often there's any legislative accomplishments at all, given the way Congress has been operating in recent years. So tell us about the First Step Act. What was your involvement in the development of the legislation, and what do you think are the top 2 or 3 things that it actually accomplishes?
So I'm on the board of FAM, Families Against Mandatory Minimums, one of the groups that does criminal justice reform, and I worked with FAM and with the White House on the First Step Act. And just as a side note, I'd tell you that the big winner from the November election, this past election, was criminal justice reform. Michigan decriminalized marijuana. Florida said that people with felony convictions can actually vote and participate in democracy. And there were reforms happening all over the place. And as that was going on, we were working on this federal prison and sentencing reform bill in Congress. And magically, in late December, Mitch McConnell brought it to the floor for a vote. And it got 87 votes in the US Senate. I often say criminal justice reform is the last bipartisan issue in America. And it certainly was in that case. And then President Trump signed the bill, and what it does is it reduces some of the worst mandatory minimum punishments, especially for nonviolent drug offenses. And then the other part of it is it requires the Federal Bureau of Prisons to put in meaningful rehabilitation programs, and it ties those 2 incentives. Now, you liberty economist types in the audience ought to get this. The best way to incentivize people to change their lives around and become rehabilitated is to dangle the incentive of early release. It's amazing what people can accomplish if they think it will lead to getting out of prison earlier. And I love this model that says, hey, listen, we sentenced you, we want to punish you, but guess what? You can earn your way to freedom by showing us that you've changed. And I think this bill will be, at the end of the day, it's modest reform, but it also happens to be the best federal criminal justice reform bill of my lifetime. And the really neat thing about it is, because President Trump signed it, and this was led by Republicans, what I'm seeing are Republican governors all over the country that feel they now have the political cover to do reform. Governor Matt Bevin told me from Kentucky, said, call me. Let's fix my system. I've had Tennessee reach out, Florida. States all over the place are starting to realize that, one, it's not effective tax money spent on prisons, and 2, that it doesn't actually fix so many of our problems.
So one of the questions that we have from Twitter, which is up there on the back, is what isn't in the First Step Act that you think should be in the next round of criminal justice reform?
3 things. One would be ending of all mandatory minimums. Mandatory minimums give prosecutors the ability to set the sentence. We want judges to have the power to do that. Historically, Article 3 says that's the judge's power to set the sentence. Judge has a lot more information, and the judge, at least in federal court, is kind of protected from the political process because they don't have to run for election. And so that's who we want making the decisions on sentencing. Other thing I would tell you is the US Congress does not respect your liberty. None of you. They do not respect your individual liberty. Why do I know this? There are over 5,000 federal crimes that carry criminal penalties. Heritage Foundation tried to get an accurate count a few years ago and couldn't, because Congress and administrative agencies pass these routinely every single year. You cannot tell me that there are 5,000 things that are so wrong and so bad that they could warrant sending you to jail or prison. But our Congress has passed over 5,000 of them, and so we need to scale back the federal criminal justice system. And then the last thing would be mens rea reform. This idea that you can be charged with a crime regardless of whether you knew about it, regardless of whether you had bad intent. And I think that that's a fundamental principle that the government should have to prove in order to send any citizen to jail or prison. And I think that, you know, in the future, those may be things that are on the table.
So Jerry, for you, another question that we've been asked from Twitter, and this is the question I told you I was going to ask you anyway, and that is, the question is worded, if you could change one policy overnight in the criminal justice system, what would it be? And I wouldn't limit yourself to one. That is, what are the 2 or 3 different reforms that you think are necessary in the pre-conviction phase of our criminal justice system to prevent people from being wrongfully sent to the penitentiary in the first place?
Okay, on pretrial, there's a couple of things. One, most people don't understand this, but criminal discovery procedures are very, very limited. When somebody's life or liberty is at stake, we're very stingy. You can't do depositions. A lot of the open discovery procedures that civil lawyers can employ when only money is at stake, for various reasons, you don't get. So for instance, you know, I do handle a lot of cases where there are allegations of sexual assaults. Some of them, the defense might be consent, or there's an issue of how much, if it's in college-age kids, how much was consumed for alcohol, and were they able to consent? And there's a lot of these kinds of issues. But when it comes to people in that age group, most of their interaction is recorded on texts. And so very often, if you can get the text exchanges between the parties, you can find out what's really the truth here. Was there consent? Or if there wasn't consent, well, then what about this? Or if you were too intoxicated, then why were you doing that? And you would think that you should be able to get those texts as part of your defense to prepare for it, and it's extremely difficult. And they keep trying to change the law, make it more difficult. There's a movement called Marsy's Law, which is maybe well-intentioned to try and improve victims' rights, but they're trying to enshrine it in the Constitution that would prevent them from turning over on privacy grounds or various reasons. So if, in fact, I mean, there's a lack of money, in my book I talk about a whole slew of problems. We could put more money into the system, but if you allowed both sides to have more open discovery of what the other side has before you get to trial, I think that would go a long way. So that would be one of my things. And when it comes to the trial itself, we really need forensic science reform. There's way too much junk science that's allowed into the courts in this country. Studies of DNA exoneration cases, approximately 25% of the time, there was false or misleading forensic science, so-called science, used to help convict. When National Academy of Science and other scientists have looked at this, and they found that, with the exception of DNA, almost none of the other fields of forensics have ever been scientifically validated. They didn't make the leap from use in science into the courtroom like DNA did. They were developed to help prosecutors convict people. Everything from hair comparison analysis to ballistics, all of these things sort of had their genesis in the court system without scientific rigor. And so the judges that are supposed to be the gatekeepers to keep out unreliable science, they're not good in science to begin with. Most lawyers would go to law school because we don't like science, frankly. And so
or math.
Right. Science and math is statistics and probabilities, and it's very dangerous because people watch CSI and other shows like that, and they think that science is the be-all and end-all, and that it can objectively determine guilt or innocence when it can't. At least a lot of the science that's being used. So those are two big reforms, I would say.
So what about post-conviction?
Post-conviction, we have this doctrine of finality.
And isn't that important?
It
How
is.
many trials should people get?
All right, so my answer to that is they should get as many trials as necessary until they get a fair one that's really, with due process. But there are good reasons why we have finality of judgment. At some point, people have to move on and we have to rely on judgments and be able to make decisions. It's not because people think that there's this myth that somehow a trial or a judgment brings closure to victims when it doesn't. That's a myth. And so that's not one of the reasons I think we should have finality of judgments. But it's gotten to the point where finality of judgments has trumped, no pun intended, real justice. And to the point where courts have actually ruled that actual innocence is not enough to reopen a case, particularly under federal habeas. That the Constitution doesn't guarantee that only the truly guilty can be convicted. And it's true, on one level that's true, but it has all these other protections of individual rights and liberties to try and prevent that from happening. And if you have evidence that looks like there's a real miscarriage of justice and the innocent has been convicted, most of the time that means that the real perpetrator got off. And that is not justice for victims or anyone. So I think we need to rebalance that so that finality of judgment isn't way up here and fairness and justice is almost a afterthought.
So here's, we're out of time. Before I close, I just want to ask you one more question. I went to law school to be a criminal lawyer, and I got to be a prosecutor. You went to law school to be a criminal lawyer, and you got to be a defense attorney. Can you tell these people out here, these students out here, why they should want to go to law school to be a criminal lawyer, whether it be a prosecutor or a defense attorney?
Because one of the things that I've always loved about my job and criminal justice is that is where people really, you intersect with the human being and the law in a way that you don't in most other areas of law. Family law, perhaps, but you get to deal, as a defense attorney, I love it every day because I'm dealing with human beings. For me, it's more of a vocation than a career. You don't do it because you want to make a lot of money. If the criminal justice system isn't well funded, and whether it's prosecutors or defense attorneys, that's not where you make money if you're a lawyer. But it's very rewarding when you can try and help people and slow down this machinery of justice system that just wants to, like an assembly line, convict people with nameless, almost apocalyptic kind of view of justice that you see in science fiction movies or something. My job is to stop that, to slow it down, to make the judge look at my client, whether they're guilty or not, because even if they're guilty, who among us would want to be forever branded with the worst thing we ever did in our lives or the worst day we ever had in our lives? We're all human. We all make mistakes. And
if I can interrupt for a second,
Sure.
we have to draw this to a close,
Sure.
but I do want to say one thing because the biggest problem I see with students not wanting to be criminal defense lawyers is they say, how can you defend these guilty people? I can't defend a guilty person. And all I can say to them is, look, if it isn't for criminal defense lawyers defending each and every guilty person,
That's right.
there would not be a criminal justice protection of the innocent. It
That's right.
is the protection of the guilty that provides protections to each and every one of the innocent people who don't get charged, because they know that someday, the prosecution and law enforcement knows that someday they're going to meet a criminal defense attorney, even if they've got the right guy, and so they better make it good. So that should be a sufficient justification in and of itself for why you would want to see the guilty get a complete and full defense. With that, before we thank our guests here, I want to urge you again to purchase, go on Amazon and purchase Sean's book, Lawman. Once you start this story, you will not put it down. This is Jerry's book, Illusion of Justice, which it's an inside making a murderer and the America's broken system. It also tells his life story of how he became a criminal lawyer. And this is my book, Our Republican Constitution, in which I talk about, among other things, my involvement in the challenge to Obamacare, the Affordable Care Act, in the Supreme Court. And with that, I want to thank these guys for coming and thank all of you.
Thank you. Nice job. Okay?
Thank you. What a great panel. We are now excited to welcome Bill Weld and Matt Welsh. Yeah. So most of you will know our next two speakers, but for those of you who don't, let me enlighten you. Matt Welsh has been a libertarian figurehead for quite some time and now serves as Reason's editor-at-large. And Bill Weld was the Libertarian Party's VP candidate with Gary Johnson. He is a two-term Republican governor of Massachusetts and has been a dear friend of SFL for several years. Please join me in welcoming Matt Welsh and Bill Weld.
Thank you. Can you guys hear me? Can you hear me? Nod your heads. Thanks. Always have doubts. So sorry we didn't get the an armed bank robber up this time, although he did serve as a U.S. attorney for a long time, so I guess close enough. Reminder, you can get me on Twitter at Matt Welch for questions to ask Governor Weld. Let's just start with the headlines. While everyone was out partying for lunch here, the President of the United States, Donald Trump, announced at the White House that he wants to give DACA recipients an extra 3 years of protection in exchange if Democrats will give him $5.7 billion to extend the wall and the border fencing, and the government shutdown would end, irrespective, which I don't think is a word, of whether that's great policy overall in terms of immigration. Is that a deal Democrats should take, Bill Weld?
No, 3 years is not long enough, and I'm kind of a DACA hawk. I was very much in favor of the DACA protections. Ugly is the means, constitutionally ugly is the means of their institution might have been. So that's a important issue to me. The 5.7 billion for the wall, you know, does the president have the authority under the Constitution to say that's a national emergency? Yes, he has the authority. There are 30 national emergencies out there still pending that past presidents have announced. Would it be an abuse of his power, an abuse of his authority to say that this little wall here is a national emergency? Yeah, probably yes. And people get all tangled up these days. They're saying, well, the president has you know, the absolute power to grant a pardon, therefore nothing he does dangling a pardon in front of a person who's a defendant in crime in order to get them to go around behind the prosecutors and get information to bring back to the president, that, you know, that could be a crime. That could be bribery, trading information for something which is something of value to the president for something that's of value to the convict. So you can't stop right at the president having the power. And I thought Liz Holtzman totally was on the correct side of that in her critique of my good friend Bill Barr's memo. So no, I wouldn't have taken 3 years if I was the Dems. On the other hand, you know, I think the president could do it and run for luck all by himself if he wanted to, in terms of raw power. Whether it's a good idea or not, whether it's abuse of power or not, that's a separate question.
You think he'd be tangled up in courts immediately if he declared the national emergency?
Well, sure, be tangled up, but what I said still stands.
Yeah. So a lot of people might have forgotten, especially if you weren't born yet, but Bill Weld was nominated to be the U.S. ambassador to Mexico in the mid-1990s. A little bit of controversy around that nomination back then, but clearly you've thought about, and you're a member of the Council of Foreign Relations, you travel a lot, you've thought about immigration issue, U.S.-Mexico relations. What does our politics and this current administration, but certainly not only this current administration, get wrong about immigration right now?
Well, I think what happened is that the people who were anti-free immigration set up this boogeyman, this straw man, and they said there are 11 million undocumented aliens, like space creatures, in our midst, and they're all going to become citizens and eat all our food and marry our daughters, and you know they're going to really influence the American way of life for the worse. They don't have to be citizens. There doesn't have to be a path to citizenship. You could bring in, what we should have really is a much more robust guest workers program like Canada has. Because in the western states of this country particularly, you really need the immigrant labor from the South through the Mexican border, but it's Central Americans as well, to make two big industries work. That's the construction industry and the agriculture industry. And that's not going to hurt anybody. And P.S., a lot of these Mexicans and Central Americans, they don't want to move to the United States. They want to come up here and work doing the building or the growing season 4 months and then go back to their families. Sure, they want to send the remittance check back, but you know, that's labor for jobs that almost by definition, you're not going to find Americans who want to fill those jobs. That's very simple. It doesn't involve the boogeyman of everybody becoming citizens. We also need to increase the number of EB-5 and HB-1 visas for people who are willing to start a company or people who are particularly privileged. Otherwise, we're just educating our competition at MIT, and they're all going back to their countries.
One of the kind of framing devices, I think, or themes that has come up from opening night here at this conference with a lot of people from all over the world is that on one hand, the last 3 decades has been the most single marvelous economic story in history, with 1 billion people leaving extreme poverty, and just the numbers are incredible by every possible measure. There's way more free people in 2019 than there were in 1989, God knows. And at the same time, the last 5 years, let's say, or whatever you might put the timing on it, we've seen this rise in populism, in nationalism, in a kind of mercantilist idea. Kind of big picture, what is your go-to explanation for that seeming paradox? And do you think it's going to get worse before it gets better?
Oh, I think the nationalist rise is ugly. Charles de Gaulle, great president of France, said that patriotism is when love of your people comes first. Nationalism is when hatred of all people other than your people come first. I think that's right.
But why? Why is it happening, do you think? Why are we in this moment of prosperity, do we seem to be snarling and clawing at
the Le Pens and the
it?
Trumps of the world, I mean, they obviously, I won't say feed on, but they campaign based on the frustration that comes from changes in the workforce. And not everybody is a winner in the global sweepstakes, but you can address that by sound public policy. You can say, okay, you don't have the skill sets that you're going to need after robotics and artificial intelligence and drones and machine learning and electric and autonomous vehicles come in. 40% of the jobs that are in the United States right now won't be there in 15 years, but it doesn't mean they won't be replaced. But government could take a role in making sure that workers who are losing those jobs can acquire the skill sets that the new jobs are going to require. You have to take your head out of the sand. It requires a certain amount of prioritizing and shifting, but it can be done.
There's a thing commonly referred to as sort of the Washington consensus, which is a loose term, but I'm just going to go ahead and tar you with it anyways. But just the post-World War II kind of liberal international order of coming together multinationally, lowering tariffs over time, having kind of a US-led friendly hegemony or whatever through NATO and all of this. You could definitely say this order led materially towards prosperity. But what did it get wrong? And is part of what it got wrong, or what did it get wrong in such a way that helped provoke this backlash, do you think?
One thing it didn't get wrong was free trade and not having tariffs and sanctions be your first recourse. That's a really bad idea. Free trade, among other things, always benefits the United States because we have the most productive workers and economy in the world. I think, you look at the IMF and the World Bank over the years, is there a certain amount of elitism and we're going to tell these southern countries what to do? Absolutely. So, I think we have to have some sympathy for, we're the North, right? For the South, the lesser developed countries, to whom we're saying, well, we've had our cake. We had the Industrial Revolution. We've completely industrialized. We've crossed the goal line there. You're still on the opposing 2-yard line, but you have to sign the same sort of percentage of climate change promises to do better in 2050 that we do? No, that's not fair as a matter of elemental justice. And I think just as, I care a lot about, as you know, about social justice with neighborhoods and ethnic minorities in the United States. I think, you got to put a big hat on if you're running the United States of America and think about that for the rest of the world as well. Not that we got to give away the store, but just be conscious of their position and where they've come from and where they are now.
One thing people don't realize about you is that you got part of your start in law, especially working for the House Judiciary Committee, I believe, on the Watergate hearings back in the 70s, in addition to being a U.S. attorney in Massachusetts. So I think you might have a little bit of a more interesting speculation about things involving the Mueller investigation and Donald Trump than the average person. Where do you think this goes right now?
And I would just say Bob Mueller was my deputy in the Justice Department. I brought him from San Francisco to Boston to be head of my criminal division. He became my deputy. He succeeded me as U.S. attorney. He succeeded me as assistant attorney general in charge of the criminal division in Washington. So I know him well. He is the straightest guy I've ever met in my life. He is a Republican, but he doesn't have a political bone in his body when it comes to law enforcement. He's just strictly by the book. So far, so good. I'm not absolutely sure that, as people have been saying recently, that the Mueller report won't be anticlimactic compared to the expectations of some, at least in the media. But there's plenty of other stuff. I mean, so the Nixon impeachment was based really on obstruction of justice and undermining the rule of law, because he sent in Haldeman and Ehrlichman to say, tell the FBI, tell the CIA, this is national security. They should quash the Watergate investigation. Well, honestly, hasn't our incumbent done 6 times that much in public with Manafort and the investigations? So, I spent, and I should apologize in this hall, but I don't really apologize. I spent 7 years in the Justice Department trying to do justice without fear or favor. And we were on the wrong side of some issues. Some of the sentencing issues, such as been covered in part by the recent criminal justice reform bill, and I think they need to go further if you want to talk about that. But some things we got right, which was always insisting on the rule of law, and that's why I resigned from the Justice Department in 1988.
Let's talk a little bit about where we should go next in criminal justice reform after the First Step Act, which is the first step after all. I think it's fair to say that your views have evolved somewhat from being a prosecutor.
Quite a lot on sentencing. I think there's two things still out there to do. One is, as I've urged in an earlier panel, the social justice impact of the war on drugs on various communities, minority communities versus white communities, is staggering. If you're in a minority community, you're 4 times as likely to get arrested for a marijuana offense, 4 times as likely to get jail time after you're arrested. Your sentence is likely to be 4 times as long. That's not even that's a 64x multiple, not an 8x multiple. And I think we need to perhaps have some statutory recognition of this, and you could permit people at post-sentencing hearings to file what's called in the law a Brandeis brief, a brief not with a lot of law, but with statistics, and therefore, Your Honor, this should happen. You could open that up, and that would be, I think, a good retroactive move. The other one that's one I spend time on is in the healthcare area, treating addiction. And okay, so maybe some of the consequences of addiction, but treating that as a criminal justice priority as opposed to a public health emergency in the United States, which is what it is a grave error.
Let's go to a Twitter question here. Real Nick Cooper, not the fake Nick Cooper, asks thoughts on Trump's AG appointee, William Barr.
Well, I've known Bill Barr a long time, and he's a strong guy and a tremendous lawyer. I thought that his 19-page memo got a little bit close to not the divine right of kings, but it did say if the president has a power to do something, further to what I was saying a minute ago, like grant a pardon or declare a national emergency, Bill Barr's memo almost seemed to say you can't go behind the reasons for that. And former Congresswoman Elizabeth Holtzman has been very persuasive in attacking that, in saying that cannot be the law, because if it were, then there would be no check on an abusive commander-in-chief who abused those powers. And abuse of power is what the impeachment clause is all about.
Let's go to another one here. I'm going to botch your name. Duncanstrad, something like that. Sorry. Is Bill Weld, this is the question that everyone wants to ask, is Bill Weld running for president in 2020?
Yeah, as most of you in this room know, I made the rounds of state conventions, Libertarian Party conventions, and I'm very interested in 2020. Lately, I've become more and more concerned about what's going on in D.C. It seems to me that certain actions seem to me to go beyond a lack of stability, which, as you know, I complained about throughout the 2016 cycle, maybe even crossing the line into deranged decision-making. So that has my full attention at the moment, but I'm going to be involved in 2020.
Now, we heard last night on this stage Justin Amash say a couple of interesting things on this topic. One is that the Libertarian Party needs to make sure it doesn't nominate some Republican squish out there.
That would be me.
But two, he wasn't ruling it out himself. So question to you, should he run?
Yeah, absolutely. Absolutely.
And would you then not run if he did?
No, I've never encouraged anybody not to run, and I wouldn't promise to do something based on what somebody else did, but Justin is a hero, and I think he absolutely should run. There's at least one other person whose name you all know who's thinking about, not me, who's thinking about running for the top spot in 2020, and it's a he. I would encourage.
McAfee. He's busy with some whales right now.
I would encourage him to run as well, but I think it helps the L party if there's 3, 4 strong contenders up there who have this is not going to be popular, but something that they've done of accomplishment other than strictly in the libertarian vertical.
Now, I saw you, I think, about a month before the midterm elections up in Massachusetts, and your theory of the case was the Libertarian Party in 2018, this past November, needs a lot of second-place finishes, needs a lot of people to do pretty well so that you can tell the story to the media. Hey, look, there's places where the Republicans or the Democrats have withered away, and we're coming up. 2018 midterms were kind of a disaster.
Oh no, it was very disappointing. We had some second-place finishes, but they were way down ballot. I mean, I was very much hoping we'd get some at the statewide and senatorial level, and it just didn't happen.
The number that jumped out at me down in New Mexico with Gary Johnson, your friend, who got what, 15, 16%, which is, you guys got 9% there in that state. It's his state. He ran against absolutely nobody as the Republican candidate there, who beat him by 2-1 in New Mexico. But the stat that
when
came
he
out,
started out, Gary was ahead of him by 2-1.
Right, so it flipped. But early voting there, about a week or 10 days before the election, you could see that 15% of all Democrats, more or less, had already voted. Bill? 15% of Republicans had already early voted, but only 7% of independents and third-party members had used early voting. The passion is in negative polarization. The passion is in hate. So when you have a huge high turnout, like you did, this is the largest turnout in midterms since God knows when, before my parents were born, then they don't go third party.
No, I'll say one last thing in 10 seconds. I think one mistake that Gary and I might have made in 2016 is we put enormous emphasis on the villainy of the duopoly and how the R's and the D's and the Reds and the Blues, that's really awful. But we were almost arguing you have to vote for us because we're coming right up the middle of the highway. That's almost as bad as what the R's and D's do. They say you have to vote for us. So this time, I think the L's in 2020, we got to stop dribbling around the court with these indirect arguments. We got to run right for the hoop.
All right, with that basketball analogy, thank you to Bill Weld, and thank you everybody else.
All right. One important announce we have is the winner of our Great Communicator Tournament, sponsored by Think Freely Media. In the tournament, attendees were judged on their ability to make the best case for Social Security reform. The winner gets to take part in a national final with a $10,000 prize. And the winner is... Do some drumming sound. Trace Mitchell. Where are you, Trace? Stand up. Congratulations. All right, so before we close out the evening, please help me welcome SFL CEO, Dr. Wolf von Laer.
Hi, Casey. Thank you. How is everyone doing? How many of you got 8 hours of sleep yesterday? Responsible human beings, and he won the award. I mean, I saw some people here in the front actually also being very good. I'm very, very, very amazed by libertarians. They can sit here, they can listen to a criminal justice reform panel and take a power nap at the same time. Only here at LibertyCon you will see this incredible skill. So, ladies and gentlemen, when I was a student volunteer for Students for Liberty in 2011, we organized the first European LibertyCon. And we thought, like, how many libertarians are there in Europe? Like 5, 10, if we get them? Like from France, nobody will be coming? No. However, like within a short span of a year, or less than that, we organized the first European Students for Liberty conference. And it attracted 220 people from around the world. And all of the volunteers were there. They ran that thing. It was not as professional as this year. We did everything. We didn't sleep. I slept off an air mattress, which didn't have air, on the floor. And we did it all very low-key. And it was such an amazing feeling. I had energy like for 5 people. I didn't sleep. I didn't need any sleep because I was so buzzed to meet other people that share the same ideas, the same ideals, and the same passion for this. And I saw, holy shit, there are other people out there who believe in this. And now I'm really deeply honored to be here to help you experience hopefully a similar feeling and that you see that you're not alone. Yes, we are so many more and it's not like that unique anymore and there's so many events, so many organizations, but I hope you got a little bit of that sense when some speaker touched you or when you learned something new that changed your mind. And I want to thank all of you for being here, for traveling from all across the United States, all across the world to be here with us because we put a lot of time and energy into this, and our sponsors put their money into it, and we really, really appreciate it. And I really want to thank our sponsors that made this possible: Google, Bitcoin.com, Reason, as well as Washington Times. So thanks again, all of our sponsors. And I want to really thank our staff that was working tirelessly for months to putting this together, to get the social media out there, to invite you, to do all the little things that you don't see in the background so that you are getting alcohol and fed and like the air conditioning is fit and like all the important stuff in life. And I really wanted to give a special shout out to, I don't know where they're sitting, David Clement. There I see him. Come, stand up, man. He's our token Canadian, and he was running all of this. And also, of course, Laura Cheplak, our Chief Operating Officer. Where is she? Is she here? Laura? No, but anyways, thank you. And I hope you stay in touch. There's many things that you can still do. We have SFL Academy if you're interested in the ideas. We just launched a new course about Bitcoin and ledger technology. If you still don't know like what all that craziness is about, you can check it out online. We have a course about liberty in Africa, where African scholars explain why liberty is needed in Africa. So it's not like white people explaining to Africans how that works. We have all kinds of different, very educational courses. And if you're a student, please check out our training programs. I mean, I wouldn't have a fraction of the skills I have today without them if I wouldn't have been a big part of SFL, and it's life-changing, so I hope you check it out. And that's really it. However, there's still more fun. So we are happy to have another social. So that's not only just talking. Nobody's talking at you anymore. No more German accent. You don't have to worry. So tonight's social is sponsored by Young Voices and the America's Future Foundation. And Young Voices is a non-profit PR agency that helps libertarian students and young professionals get into the media, and they're doing a terrific job at that. If you're under 30, then definitely check them out and visit their booth, because it could really launch your career as a journalist. And the America's Future Foundation is a community of ambitious and inspired young leaders who are working to advance the ideas of freedom at home and on a national scale. So please check that out, enjoy the drinks, enjoy the food, and please come home safely. See you next year from April. Where are the slides? We had slides. Did you see the slides? All right, you saw the slides, you saw the dates.